welcome to this video lecture on drafting regular second appeals, which is part of Unit 7 of our advanced program on civil drafting for practicing advocates. Hi, I'm Richa Kaur. In this video lecture, we'll learn about drafting pleadings for regular second appeals.
Hi, I'm Aditya and I will take you through this video. Before we go over the form of a regular second appeal, it would be useful to understand the ambit of such appeals. Section 100 of the Code of Civil Procedure 1908 provides that an appeal shall lie to the High Court from every decree passed in appeal by any court subordinate to the High Court if the High Court is satisfied that the case involves a substantial question of law. As you will notice from the provision, the legal requirement is that a second appeal must raise a substantial question of law. While the term substantial question of law has not been defined in the CPC, it has received much judicial scrutiny. In Kashmir Singh versus Harnam Singh, a 2008 judgment, the Supreme Court reviewed the law and stated that a substantial question of law includes the following. While an inference of fact from the recitals or contents of a document is a question of fact, the legal effect of the terms of a document is a question of law. In other words, the construction of a document involving the application of any principle of law is a question of law. Therefore, where there is an incorrect construction of a document or a wrong application of a principle of law gives rise to a substantial question of law. Next, the High Court should be satisfied that the case involves a substantial question of law and not a mere question of law. A question of law having material bearing on the decision, that is, a question the answer to which affects the rights of the parties to the suit, will be a substantial question of law if it is not covered by any specific legal provision or by binding precedent and involves a debatable legal issue. A substantial question of law will also arise in the opposite situation, where the legal position is clear, either on account of express provisions of law or binding precedents, but the court below has decided the matter and either ignored or acted contrary to such legal principle. Now that we have learned the jurisprudence of a second appeal, let us learn how to draft a second appeal. The second appeal is somewhat similar to the first appeal in form and substance. The main document to be filed is a memorandum of second appeal. This document contains the following elements in common with the first appeal: the cause title, the heading, the body of the appeal, the grounds, and the verification. In addition, in the memorandum of second appeal, you need to identify the substantial questions of law that arise and set them out in detail, seriatim. Let us study each of these components in detail. First, let us look at the cause title. The cause title is a full cause title, similar in form to that used in the plaint document and the first appeal, save that here you will set out the details and case numbers of both the courts below and the ranks of parties in all three courts. Next, let's look at the heading of the memorandum, which will read as follows. Memorandum of Second Appeal under Section 100 of the Code of Civil Procedure 1908. The body of the second appeal is similar to that of the first appeal. First, set out the background facts. While setting out the facts, remember that no new facts that have not been set out before the court below should be asserted, and that one must endeavor to remain neutral in one's statement of facts. Always state facts that are against you as well, but be careful that the statement is not construed as an admission against you. You will, in the body of a second appeal, also summarize the proceedings before the trial court and the first appellate court by setting out the contentions of each party, the issues framed by the court, the number and identity of witnesses that deposed on behalf of each party, the findings of the court on each issue, and the final judgment and order. Next, As in a first appeal, set out your grounds of appeal as formulaic statements of reasons that you think that the judgment of the trial court is wrong. Ensure that you have set out the appropriate procedural provisions regarding address for notice, limitation, jurisdiction, and court fees. The prayer column is similar to the prayer column in the plaint and in the first appeal, except that here you will request the court to set aside the relevant judgments of the courts below and to decree the suit or dismiss the suit as the case may be. As with the first appeal, an affidavit is not required for a memorandum of second appeal since no new facts are stated. However, it should carry a verification which is of a similar form as that contained in the plaint document and be signed by the party or his advocate. Additionally, a valuation slip of similar form as that contained in the plaint and memorandum of appeal is also needed. This concludes our video on drafting a memorandum of second appeal. Please attempt the practice exercises before you move on to the next unit. Thanks for watching.